Welcome to The Print. In this third episode of our series, Laws of the Land, I'm going to begin it without any fancy introductions or stories because the law that we're discussing today is UAPA, Unlawful Activities Prevention Act 1967 और आजकल इस law का नाम ही काफ़ी है. But just to give you a bit of background, the law has its genesis, like I said, it was passed in 1967. And it has its genesis back to a committee report, the committee which was tasked to look into reasonable restrictions that can be placed on certain freedoms in the interest of integrity and sovereignty of India. And that's when the law was born. But I feel like it really came into its element in 2004 when terrorist activities were brought under its fold and it became was christened as a successor to TADA and POTA in a way. And since then, the law has undergone through an evolution of sorts, through a journey, through amendments, through judgments that have interpreted, and that's interpreted the law, and that's exactly what we'll be talking about in today's episode. To discuss this, you have me, Apurva Mandhani, you have Bhadra Sinha, who you've often seen on our YouTube channel, and we have Mr. Tanveer Ahmed Mir, who is one of India's leading criminal lawyers, so he'll be the best person to talk about the law to us. Bhadra, if you'd like to take this forward.
Welcome, Tanveer. So before we go ahead and talk about its evolution and the history, I would like you to just briefly tell, for the sake of our viewers, that why is this law a very draconian or a stringent law? What is the reason, if you could just tell us briefly about it?
Thank you very much first for inviting me to this wonderful interactive program. Well, in very simple words, the law has attained certainly a draconian nature from 2004 and especially in 2019 amendments, because the intent in 1967 or thereafter was to kind of ban those organizations or keep those organizations in check which are geared towards seceding territories from India. So that was a cause of national integration, taking into account that right from infancy, since we attained independence, the far-flung areas were again kind of having their own structures and least allegiance to New Delhi. Now, after the national integration was done, there were problems in northeast, there were problems even down south, there were problems in north. So the law was basically to discourage organizational structure which is geared towards seceding territories from the Union of India. After 2019 especially, and even after 2008 or 2004, the central government vide an amendment has garnered to itself that even a simple individual can be declared as a terrorist without any checks and balances. And before he realizes what has hit him, he has to spend about at least 180 days in jail. Normally, as per criminal procedure, even in very serious offences like multiple murders or serious felonies, a final report or a charge sheet would be liable to be placed before a court in 90 days. But here is 180 days.
So this is the first reason why
the law becomes draconian. Until then, virtually you have no hearing. You cannot even move a liberty petition except that this will be dismissed. Secondly, there is double the remand that is normally in a normal criminal case. Here it is 30 days.
30 days at a stretch, you can be sent on remand.
Correct. To a police custody, where we know usually in cases like these, there is a lot of third degree. There is coercion, intimidation, extraction of statements, inculpatory or otherwise. And finally, there is reverse burden. The burden is now on the accused rather than on the prosecution. And the chances of a person being set at liberty are virtually none by having an escalated bail jurisprudence via a provision called 43D subclause 5, which provides for a very, very stringent mechanism of bail, which means that a court has to first see whether the allegations as presented by the prosecution are prima facie true. So if the prosecution is given that kind of a wavelength, sometimes the investigating officers extract statements, sometimes they intimidate witnesses into giving inculpatory statements where the witnesses may not be actually willing to do it. And till you are at a stage of trial and the cross-examining lawyers are breaking down the witnesses in the court, it's already about 7 years in prison, 6 years in prison. That is what we are seeing in all the cases where you're getting prosecuted. Also post 2008, you have something called as a National Investigating Agency, which, has borrowed cadre, and that has adorned it to itself to sort of, investigate all these cases. Their tactics in investigation is also, fraught with a lot of suspicion. And in certain cases, the NIA, for example, in the Mecca bomb blast case, Mecca Masjid bomb blast case, you had a charge sheet against certain people, but when further investigation was handed over to NIA, they tried to dilute their charges, thereby, paving a way for the accused persons to be let out or to be discharged or to be virtually allowed to go scot-free. And where on other sides, you are on a spree of implicating people. In lot of these cases, what we are seeing in the district courts, at least in Delhi, I can tell you, is that there is about 8 years of custody where before a person sees liberty. And most of the time, the accused are then compelled to, virtually say plead guilty so that they can receive a sentence. And, in case they get whatever, maybe they may get life, they may get lesser. At least they know that it is about 3 years more and then they can go home.
No, so as you pointed out that, by the time the witnesses are cross-examined in the court,
Correct.
It's almost 7 years.
Yes.
So when we talk about UPA cases,
Yes.
UAPA cases, as a lawyer, what do you say or what do you think could be the reason behind this kind of a delay? Is it the provisions in the law that are reason for the delay, or is it the delay is the delay on the part of the investigating agency? What could be the cause of the delay?
I think it's a bit of both, and that's very disappointing. For example, the court and the statute obligates an investigating agency in a UAPA offense, that may be local police, that may be NIA, to mandatorily file their final report within a period of 180 days, lest the accused will get a default bail.
Yes.
But when it comes to supplementary investigation, there is virtually nothing. There are no limitations. There are no timelines. So last year, Honorable Justice Anup Jairam Bambani of Delhi High Court, in one of the money laundering indictments in Religare scam, said that further investigation cannot be whims and fancies of the investigating authorities. Unfortunately, that judgment got stayed in the Supreme Court, and the 3 judges bench did not pass any reflection on it. So what is happening in UAPA cases is, though the first charge sheet will come on the 178th day, or even prior to that. But then NIA will say that, Your Honor, we are investigating more. So further investigation that keeps on pending for another year or another 2 years. Then some more people may get indicted. Then they'll say, we still further investigating.
So is it that till the time a supplementary charge sheet is filed, is it that the courts do not entertain bail applications, or is it that the accused cannot file bail applications? Is there a bar under the law?
Yes, thank you very much for that question. There is no bar under the law. When I was answering this question, Bhadra, I was answering it from the point of view of when does the trial trigger. Now, a designated judge under UAPA oftenly and ostensibly does not start a trial against the accused till the complete investigation is done.
And complete investigation would include filing of supplementary charge.
Yes. So the Honorable Court would expect the prosecutor to make a statement or the IO to make a statement that no further investigation is pending. This is the total case that we have, and it is always a case of conspiracy. So therefore, it is only after that that the trial commences. So in certain cases, for example, if we keep UAPA on the sideline and talk about Augusta Westland scam, that started in 2014. And today it is 2022. Still the trial has not started. In many of UAPA cases also, it is almost about 4 years before the court calls upon the defense counsels to present their arguments on charge.
Okay, okay.
And you can file a bail plea once the charge sheet is filed, but the court will not grant you bail 99% because the court, on two reasons. A, on pending investigation, and secondly, court will say that at this moment, I will have to consider everything that the prosecution has placed on record as the word of Almighty God. So till you actually break up that evidence in cross-examination, your liberty is not seeing the light of day.
That's actually, since you mentioned that point, now we've spoken about how the provisions of the law itself are quite stringent.
Yes.
But there are also judgments that have, in a way, with their interpretation, made it more stringent. And here I'm talking about the Zahoor Watali judgment.
Yes,
So if you
yes.
could address that a
Yes.
little bit for our viewers.
Now, if you see Zahoor Watali's case, that is also called as the Kashmir terror funding case, the first Kashmir terror funding case. And in this case, a division bench of Honorable Delhi High Court granted bail to Zahoor Watali. Thereafter, when this matter was challenged by the government before the Supreme Court reversed it. And in that judgment, what they said is that for the purposes of considering your bail application, we will have to see whether the material which is relied upon by the prosecution prima facie, without subtracting anything from that material, without putting that material to any kind of test of veracity, of correctness, the prima facie truth of the allegations is made out against you. So even if those allegations are absurd, even if those allegations are prima facie contradictory, the contradiction is read out, because contradiction by a defense counsel can only be called into play when he steps his foot into the witness box and starts cross-examining the witness. The interpretation in Zahoor Watali has actually strangulated all the high courts, all the trial courts, because now that has added ammunition to investigating agencies, of which a great misuse also happens. For example, you get two witnesses from a fish market, a vulnerable witness, a weak witness, and you write his statement out of coercion, intimidation. Tomorrow that witness may not own his statement. But for the time being, till that witness will come into the box, his statement will be read as gospel truth. And if that statement is inculpatory qua the accused, he's done and dusted for 6 years.
So this was the interpretation by the Supreme Court.
Correct.
Okay.
This is the interpretation done by the Supreme Court, that till the stage of testing the bail, only the prosecution docket will be taken into consideration. Though an accused can also file something contradictory on his own, but those kinds of materials are kept in the shelf. The courts tend to, and rightly so, since they have to follow Zahoor Watali, unless and until Zahoor Watali is not distinguished or is melted down, or there is another bench which looks at it from a different perspective. The net result is that anybody and everybody who will be booked under UAPA, especially Chapter 4, Section 15 onwards, for which you have the twin conditions in 43D5, easily, always and ever, it will be at least 4 to 5 years on an average before he can actually see any chance of seeking liberty.
But subsequently, recently there was another judgment by the Supreme Court where a judge headed by the then I mean, he's of course a former CGI, but at that time he was not, Justice Ramanna. He, talked about delayed trials and also said that in UPA cases, bail should be granted in case there is, a delay in the trial of the case. So,
Yes.
has that impacted or has that had some sort of,
Sucker. Not at all. See, that is a judgment which I believe was passed, which was reiterated, but I think the base judgment is of 1994, and that is Supreme Court Bar Association judgment. And that says that if a person is facing trial and has at least spent half of the sentence which he can get tomorrow if he is convicted, and the trial is not coming to an end, it is time to let him go, at least. So in all, say for example, you are indicted under section 15 and you're looking at life sentence. Now you may say that life actually is life, but we may look at it that if you are a first timer and you don't have an egregious record, maybe you're looking at 15 years or 16 years, say with parole, without parole. Then the court would say, all right, 7.5 years done. Let me now let you go on Supreme Court Bar Association. But that's 7 years. The biggest problem here is in contradistinction to a case of murder, where I can go to a court and get a bail on the next day if I'm able to convince the judges that this case is totally loaded and it does not have legs to stand on. And the escalated bail jurisprudence doesn't come into play. There the court may grant you bail, but here, one witness against you being fabricated or being loaded, couple of lines being added in the witness statement. Now, these witness statements are actually, unfortunately, as per the court, they're not signed statements. Okay. Now, they're not even digitalized statements. They're not videographed statements. So a judge, for example, if it's a videographed statement, then the judge can look at the demeanor of the witness who's making that statement, exculpatory or inculpatory. Yeah. Now, when you are writing a statement of a witness, which is an unsigned statement, there is also an element of little bit of discretion. You may write 4 lines more. The witness wouldn't even know what was written. So tomorrow he may seek a divorce from those 4 lines when he actually steps into the witness box. But by that time, 7 years are down the drain. And the man or the person who is in custody is finished.
So, Tanveer, actually this UPA succeeded 2 anti-terror laws,
yes,
TADA and POTA. So, do you see any difference between UPA and these 2 earlier laws, or is it just the same? Have the provisions from these 2 laws, have they been retained in UPA, or UPA has become stricter than the earlier?
I believe UPA has become far more stricter. And the reasons why POTA and TADA were repealed, because we know that the communities were targeted under that, and you had 8-year-olds being booked under TADA. So there was strong misuse of the law, which led the government to repeal the law. The moment you have got individuals into UAPA rather than organizations, and a law which was garnered and geared towards banning organization or keeping a check of organizations who have secessionist ideologies, whose ideologies are to break up certain parts from India, now has turned on its head. And now what we see is that, for example, somebody is a human rights activist and he is not calling for any kind of secessionist activities, but is wanting to be a watchdog of the society. He's also booked under that law in one way or another, and that's a very, very easy way to clamp him down and throw him in a dustbin for next 7 years.
So are you saying that prior to UPA,
yes,
under TADA and POTA, individuals were never booked as terrorists?
No,
or,
individuals were. Now, because there was a misuse, so that's why the law was repealed. The essence of UPA was in banning organizations, not individuals. The moment you get individuals under UAPA, then there is blatant misuse. Then you can target a person, that you can call him, for example, if a person is socialist and he wants, the farmers' rights, he wants equal remunerations. he's against capitalism, you can easily call him an urban Naxal and book him under UAPA. So it's the UAPA individual indictment actually intends, works and executes itself in killing the voice of dissent and questioning.
We want to understand how that happens though. So is it, if we talk about the definition of terrorist activities under section 15, is it wide enough? Of course, every law is open to interpretation, but does this law allow more of that scope to bring larger and larger sort of activities under its ambit?
Yes, absolutely correct, madam. The law is very loosely worded for the investigating authorities to book anybody. For example, ordinary protesters can be booked. If a riot takes place, then rioters can also be booked. Now there you are seeing in present times a clear act of executive discrimination. Now when you will see a certain law like the activities in which this Sharjeel Imam and Umar Khalid are indicted in NRC. So you will see a lot of UAPA indictments. But when there is a riot on military jobs and the buildings are burnt and railway stations are burnt and public property is damaged, you will not see anybody being booked under UAPA at all. Normal law comes into play. Also, specific communities and people belonging to communities are specifically targeted. Now, you're looking at people belonging to that Popular Front of India. They are also being booked under UAPA. Now, the way this 15 is drafted, even tomorrow an ordinary protest, say a protest on hunger, a protest on farmers' crops, minimum remuneration, jobs, tomorrow may lead to a riot and burning down of public vehicles or public buildings. Now, this is an ordinary crime. Prior to this, we would never see violence in a protest being booked under Poda Tata.
Okay, this was never a practice.
This was never done.
Okay.
This was never done.
Ordinary
crimes of protesting, ordinary crimes like farmers' protest, military job protest, NRC, CAA, for example, a protest against, religious endowments, bringing about religious structures or temples or mosques, that may evoke some emotive response from the general public at large. Now, I recollect I defended Gurmeet Ram Rahim in 2 of his cases, and once called as a Panchkula carnage case, where 38 people were shot dead, I believe in August 2017 when he got convicted. But UAPA was not indicted. It was not called into play. Had you called UAPA into play, nobody would have got bail.
But the definition was still there at that time, right?
Yes.
So is it the usage, is it the way that it's being used?
Absolutely. You see, though you had section 15 at that time, but it is post 2019 that you can book individuals. And after you can book an individual, you can declare him a terrorist. And tomorrow he has some appellate authority review, but ultimately he will be booked. And by the time it is 5 years, he would not even see sunshine.
So, as far as the intent of the law is concerned, are there any reservations vis-a-vis that? Or is it that the discriminate use of the law is a problem?
Actually, the problem here in such a situation is that the amendments which are being made, especially in last so many years, say about last 8 years, are amendments being all done through the mechanism of money bills. Now, what money bill does is that it introduces a whip. There's virtually no debate in Lok Sabha, and Rajya Sabha debate goes into a canter. Ordinarily, what the parliament used to do is, when there is a change or amendment in substantive criminal law, you would have dedicated parliamentary committees. You would throw the amendments to general public at large for participation as to what would be a response from, various groups, various stakeholders, people who are watchdog societies, looking into your past that even previously the draconian laws have been subject of repeated abuse, which abuse has also been recognized by the Honorable Supreme Court of India on a number of occasions. Therefore, when you amend this law and bring individuals, now that's a targeted amendment. The targeted amendment empowers, a law enforcement agency which is virtually under the jackboot of the government to act and to investigate in a particular form and in a particular manner, though they would say that we are doing it transparently, but actually they are not. And that results in dissenters, people, for example, toolkit people are getting booked under UAPA, 18-year-old people, who have a voice of dissent. Now, anybody can tomorrow not agree with the government. Now, you cannot have laws in a democracy which tend to virtually stomp out the right and human curiosity to raise a question, to have a voice of, a voice of dissent. Because if you kill dissent, you will kill the society.
But we are talking a lot about the investigating agencies. How about the judiciary?
Yes.
Because after all, these cases end up going to the courts.
Yes.
How have the courts treated such cases? Have you had any judgments, deliberating specifically on misuse of the law, on the point of, the Section 15 being very widely worded? Have you seen any judgments on this point?
Unfortunately, Bhadra, no, and I'll tell you why. The misuse of the legal machinery or misuse by the law enforcement agencies comes into play only when the full trial is done and dusted and the witnesses have testified. The judges are then able to, filter out the evidence and understand whether, the evidence was deliberately created. In all UAPA indictments, there are cases out of Bangalore where 12 years, 13 years have gone and trials are midway. The misuse only comes to the fore to a two judges bench or to a trial court or to the Supreme Court when they are looking at the crystallized evidences. For example, let me give you an example of the famous Arushi Talwar Hemraj double murders. The division of Allahabad High Court, looking into the entire evidence and investigation of CBI and how the witnesses testified, returned a finding that witnesses were forced, coerced, intimidated in giving a particular kind of testimony. Now that will come to the fore only when trials are done. Till now, the Supreme Court in UAPA cases is only looking at bails or default bails.
But the thing is, not everybody can go to the Supreme Court. So I want to understand, is there something that the lower judiciary can do, or does the law itself does not allow them that space to have certain checks and balances in place at all?
This is a misfortune. As far as the lower judiciary or district judiciary or original trial court is taken into consideration, it has two deadly limitations. One is the statute itself. Second is the decided precedents coming from the higher courts. So if you have a judgment like Umar Khalid coming from a division bench of Delhi High Court or a Zahur Watali coming from Supreme Court. Now, Supreme Court in certain cases has talked in a different language also. But if these are the determinative 2 judges, 3 judges bench, then actually the trial court, even if it wants to break free, finds itself shackled. So then they have to follow the dictum, they have to follow these rationales that whatever prosecution will present will be gospel truth till the prosecution case is actually broken down by defense counsels in cross-examination. Now, if the cross-examination, now either you have to have a mechanism where the legislature passes an amendment that no agency in India is allowed to have more than, say, if you say 180 days time, let's say peg it at 1 year. So no investigating agency can go beyond 1 year in investigation. And after 1 year, every UAPA cases must be decided in not more than a year and a half. Then even if somebody gets booked rightly or wrongly, he can have a quick and expeditious trial. So by the time 10 witnesses are done, and you have done, say, about a year and a half of custody, and there is material coming to the fore that the prosecution case may have very strong chinks, any court may be willing to bail you out. Unfortunately, we don't have that kind of a system. Our trial judiciary is also overburdened. Any trial court in India doing serious crime will at least have 15 cases of evidence every day. In UAPA, even the NIA, on an average, will file a charge sheet running into at least 8,000 pages. The witness statements are at least 12 pages, 13 pages. Examination in chief takes 2 days. If examination in chief will take 2 days, cross-examination will take at least 3 days. So you can do 1 witness a day. Other 14 cases will get adjourned. So a person who is in UAPA, the normal trend which I am seeing is that even persons who are 3 years are either going into serious depression with mental ailments, or somebody is coming to the court and saying that Judge Sahab, I want to plead guilty. आपने जो सजा मुझे देनी है सजा दीजिए, और मैं जो है भी अपना दिमाग सेट करके अब मुझे यहाँ 15 साल रहना है, मैं साइड में होके 15 साल रह लेता हूँ.
I think that is how most of the UAPA cases are getting concluded, you know.
Absolutely.
They are not
Even
getting
the
contested.
prosecutors are telling the accused, I have seen many a time, कि आप better plead guilty कर लो. They will achieve their targets that we have a good conviction rate, whereas actually they have none. And their job is achieved. And we have actually not therefore allowed a fair trial at all.
So is it that a trial court cannot fix a deadline for any prosecuting agency to complete its investigation?
Virtually not. And that is a big misfortune. Because under 173(8), under 173(8), there is no statutory limitation available for the judge, except on each of date of hearing to give a mouthful to the investigators. But those people, you know, they don't mind the mouthfuls, because at the end of the day, you know, you have received so much of a mouthful that you converted yourself into a pachyderm.
But another thing which I am very keen to ask is that understood that the prosecuting agency wants to carry on with investigation, wants more time to file a supplementary charge sheet. But what bars the trial court from commencing the process of trial for those who have already been arrested?
Yes, that's a very important question. 99.9% of UAPA cases are conspiracy based. Okay. If the prosecution says that there are more conspirators, okay, therefore the persons who are in custody have a right and court is obliged to put them to a joint trial. Now, if for example the trial 3 accused starts, 3 more accused are coming 2 years down the line, all witnesses will have to be called once again. Okay. So the court is shackled. Right. So court will have to do a de novo trial. Right. Say you have already examined 30 witnesses. Right. Now new accused get added who are in conspiratorial charge with the earlier accused. Right. They will say that, Your Honor, we have a right to cross-examine all the witnesses. So you will have to start a de novo trial. So what would ordinarily take 4 years will take now 9 years. So the trial court says that, all right, this is a conspiracy case. Once you finish the supplementary, I'm going to start a trial, because I cannot afford a situation that tomorrow I will ask 40 witnesses to come here from nooks and corners of the country, and then I am sending a summon again, because at the end of the day, the law also cannot perpetuate itself, which leads to harassment of witnesses.
This is true.
Right.
So we've gotten ourselves into a big hole, and it is up to the legislature first to divorce the money bill. Secondly, whenever they are going for substantive amendments in penal law, as you see in democracies all over the world, you have to have that debate in the parliament. Even if the parliamentarian is not worth it, you have to have expert committees. You have to take suggestions from expert committees and then bring in those amendments. When you bring individuals into UAPA, you also have to see whether there is necessity to do so. if you can tackle individuals under normal law, then why do you need to call them under UAPA? There is only one ploy, because under normal law, at some point of time, some lawyer will go to the court and will say that, Your Honor, this is normal bail jurisprudence. And therefore, court may be inclined to grant you a bail after years of custody, 1.5 years of custody. But where there is escalated bail, for example, UAPA, money laundering, or in cases of SFIO, or NDPS, or narcotics, you virtually see the statute itself then provides that the rule is jail and not bail. So the bringing in individuals means that you ensure that he ain't not getting out of the jail for next 6 years. Objective is achieved.
Finally convicted or not.
That they don't bother, because let me tell you that whenever all these cases go to a logical conclusion, the conviction rate is not even 3%.
I remember that happening in Tara cases.
Yes.
Most of the
Yes.
cases used to end up in acquittals because
Yes.
of very bad investigation and lack
See,
of forensic investigation.
The classic case, there can never be a bigger case than Parliament attack. You had Pota, you had 3 death penalties to start with, and 1 5 years conviction for the lady. Cometh the first appeal, 2 acquittals, 2 convictions. Cometh the Honorable Supreme Court, 3 acquittals, 1 conviction. And the problem with those laws were that confession before higher cops was admissible. The man did never see even the higher cop. In some of the cross-examinations that I did early in my career, I was able to establish in Pota cases that the DCP was not even in his office when the confession, had been allegedly recorded. Because they just used to do those investigations in their offices, have a confession and rock and roll. In today's time, you have confessions, those are admissible. You have reverse burden presumptions. You have escalated bail jurisprudence. You have individual marked as a terrorist when he's only a human rights activist, or an opponent of the government, or a dissenting voice, or a person who doesn't like a particular policy. So it is easy to brand somebody as a terrorist under 15 and say, thank you very much, please go to jail for next 7 years.
With this, we've reached the end of this episode. In this episode, like I said, we spoke about UAPA, we spoke about why the law is called draconian, what are the provisions that are working against those accused under the law, and how the entire system, in a way, the law in itself, its provisions are stringent, but also how the investigating agencies as well as judicial interpretation has added to the law becoming even more stringent over the past few years. I hope you enjoyed this episode. Thank you so much for joining us,
More than
Tanvi.
welcome. Thank you very much for having me here.
And thank you so much for watching this show. Do let us know in the comment section what you think about it, and keep following us the way you do.